So welcome back to Contemporary Business, and I'm Ivor Blumenthal. This is an extraordinary interview because, in fact, it's going to be an interview of myself. I am the representative for the South African Paint Manufacturing Association on the National Bargaining Council for the Chemical Industry. And as an executive member of the National Bargaining Council for the Chemical Industry, I thought it was appropriate if Tara Ben, the CEO of SAPMA, were to ask me about something which is coming down the tracks very, very quickly, which is the extension of the industrial chemical agreement within the National Bargaining Council for the Chemical Industry, and what the likely impact of the extension of that agreement is going to be on SAPMA members who currently are not members or parties. The term is parties to the National Bargaining Council for the Chemical Industry.
Can you explain the Minister of Employment and Labour's role in extending the collective agreements, and under what legal authority this extension takes place?
So the bargaining council itself is currently a voluntary bargaining council, which means about 30 years ago, employer associations, including, by the way, the Surface Coating Employer Association, which falls under the umbrella of SAPMA, but employer associations sat down with organized trade unions and created the bargaining council. Now, not all employers at the time were members of the employer association. In fact, very few were. And not all employees who worked in surface coating were in fact members of the trade unions. So it was a voluntary agreement between some trade unions and between some employer associations. Like I say, not all of the employers were covered. So the employers who were part of the Surface Coating Employer Association would be referred to as parties, and the employers who are not part of the Surface Coating Employer Association but are part of SAPMA or are not members of any association would be referred to as non-parties. Now, about 10 years ago, the Minister of Labour at that time introduced the concept of allowing voluntary bargaining councils to extend their agreements to cover non-parties. And the reason is very simple. Not enough companies are members of bargaining councils and therefore are paying their membership fees to bargaining councils, or in fact are members of the trade unions and their employees paying trade union fees. So it really is an economy of scale game that has caused parties to apply to the minister to extend the voluntary agreements to cover non-parties, the companies which currently are not members of the bargaining council and are not paying levies to the bargaining council, and in fact are not keeping to the bargaining council sectoral agreements, such as in our case, the industrial chemical sectoral agreement. It can be argued that the companies that are parties to the bargaining council are talking about unfair competition in the sense that they are having to pay bargaining council regulated minimum wages, conditions of employment, for example, maternity leave, for example, normal leave days, etc., etc. And their argument is that the non-parties, the companies that are not members of the Surface Coating Employer Association but are members of SAPMA or are not members of any association, those non-parties are getting away with not having to pay minimum wage, not having to keep to the minimum conditions of employment that have been agreed to in the bargaining council, and therefore getting away with blue murder, and therefore the opportunity to say to the minister, create a level playing field for all companies in the coating sector.
What is the current status of the wage agreement within the National Bargaining Council for the chemical sector, otherwise referred to as the NBCCI, particularly regarding the Surface Coatings Employers Association?
So the last agreement that was entered into by the Industrial Chemical Chamber, and there are 4 chambers within the National Bargaining Council for the Chemical Industry. The last agreement that we entered into for industrial chemicals, which includes the surface coating sector, was in July 2024, and it was a 2-year agreement, which means that it was 2024 to 2025, and then on to 2026. So the next negotiating phase for the agreement for July 2026 onwards will begin in the first quarter of 2026.
What does it mean when the Minister of Employment and Labour extends a bargaining council agreement to non-parties?
Let's take the industrial chemical agreement in the National Bargaining Council for the chemical sector as an example. The industrial chemical agreement regulates minimum wages at 10,500 Rand a month, plus annual increases of between 6.5% and 7%, and a whole series of conditions of employment for companies which currently are parties to the bargaining council. So when a minister extends the agreement to cover non-parties, from the moment the extension gazette is published by the minister, all companies operating in the coating sector, the industrial chemical sector, are from that moment required to implement the minimum wage at the time, which, as I've said, at the moment is 10,500 Rand. In all likelihood, by the time the minister extends the agreement, it's going to be about 12,500 Rand plus conditions of employment that have been agreed to cover all companies. Doesn't matter if they're a member of the Surface Coating Employer Association or not. It doesn't matter if those companies are registered with the bargaining council or not. Just to repeat, the moment the minister signs the extension agreement, every company, including non-parties, is automatically, immediately required to implement the terms of the industrial chemical agreement within the bargaining council for the chemical sector. In other words, let's say an agreement is signed on the 15th of January. By the end of February, the company is having to pay minimum wages and conditions of employment which are in the industrial chemical sectoral agreement, irrespective that up until that time, they have not had to implement those minimum wages and conditions of employment, and irrespective that up until that time, they haven't been a member of any of the associations which are party to the bargaining council.
Who qualifies as a non-party in this context? Does it include employers or employees who are not members of the Surface Coatings Employers Association or affiliated unions?
Just to remind people, a non-party is a company which is not a member of the Surface Coating Employer Association, is not registered with the bargaining council, and therefore currently does not implement any of the conditions of a bargaining council agreement, in this case, the Industrial Chemical Bargaining Council Agreement. So that company is considered to be a non-party. It's not currently covered by the agreement. Employees are not really defined as non-parties because employees belong to trade unions and the trade unions are parties to the bargaining council.
With regards to those obligations for non-parties, does that refer to a company that is designated or all companies?
The term designated applies to companies employing more than 50 people that have to implement employment equity targets. It in no way whatsoever impacts on who a party to the bargaining council is or not. It doesn't matter that the company employs 10 people or 50 people. Every company falling in the scope of the industrial chemical agreement, and it's defined in the constitution of the bargaining council. So every company in the coating sector, irrespective of size, is automatically regarded to be either a party or a non-party. And the moment the agreement is extended, parties and non-parties have to abide by the terms of the agreement.
What are the potential consequences or penalties for non-party employers who do not comply with the extended agreement terms?
The moment an agreement is extended by the minister to cover non-parties, every non-party is legally required to implement the minimum wages and conditions of employment in the industrial chemical agreement. If they do not, that is a criminalizable offense. It is a criminal contravention of the law because the law is the extended agreement.
Are there any exemptions available to non-party employers who cannot afford the terms of the extended agreement? And if so, what is the process for applying for these exemptions through the National Bargaining Council?
So any company which is covered by the existing voluntary agreement or by the extension of the voluntary agreement by the Minister of Employment and Labour, when that happens, is allowed to apply to the bargaining council for an exemption either a part exemption or a full exemption from the industrial chemical agreement, normally for financial reasons. The company would put before the bargaining council an application. In that application, the company would be required to submit its financial documents. The company would need to have organized labor in the company or representatives of labor if there is no trade union sign off on the fact that the company, with the agreement of labor in the company, is applying for an exemption from the bargaining council agreement for a period of time for some of the clauses or consequences of the bargaining council agreement because of the alternative. The alternative is we cannot afford to pay these new rates, and therefore either we're going to have to close our doors or we're going to have to retrench some staff members or a whole lot of consequences that we'd rather avoid by applying for an exemption from the agreement for a period of time.
So just on that note, when the Minister of Labour, Employment and Labour extend that agreement, and this is a question that comes up regularly from a SAPMA member point of view, from smaller companies, when that extension has happened and those smaller companies cannot afford to pay those the wages that are currently stipulated in that current agreement. Am I right in saying that no Section 189s will be allowed to take place?
If a company doesn't apply for an exemption from the bargaining council agreement, the company will not be allowed to implement Section 189 processes by saying, well, now suddenly we're faced with 10,500 Rand minimum wage when we're currently paying 6,500 Rand minimum wage, etc., etc., etc. Because the department have said this. The department have said, you've seen this train coming down the tracks. You've been warned repeatedly of the fact that there's an extension agreement in the making. You've had an opportunity to comment on the government gazette that says there's an application for an extension of the bargaining council agreements. You've not done any of that. You've not participated in any of that. And you've not applied for exemption from the agreement. And as a result, we are not going to permit you to a Section 189 process and possible retrenchments on the basis of this problem now, which is partly of your making as the company for not having acted sooner.
And how long is the extended agreement valid for? Is there a specific renewal or review dates or periods that non-parties should be aware
That's
of?
such a good question, because the reality is the moment the minister has granted an extension of the National Bargaining Council for the Chemical Sector Agreement, that is in perpetuity. That's forever and ever and ever. And so the bottom line is, as the agreements are renewed, in our instance, we've said they'll be renewed in 2026 for industrial chemicals. Each time the agreements are renewed, the extension of the agreement means that both parties and non-parties in perpetuity are affected by the extension of the bargaining council agreement.
In your view, what are the pros and or cons for non-party employers being bound by an agreement negotiated by parties they do not engage with directly?
If a non-party, a current company that's not covered by the bargaining council agreement, is going to be affected by an extension of that agreement because the minister extends the agreement, what are the pros and cons? If that non-party, that company that's a non-party, is also not a member of SAPMA or a member of the Surface Coating Employer Association, well, then what it means is that your competition, other companies, are going to be sitting around the table and negotiating the new agreements that affect wages and conditions of employment that as a non-party you're now going to have to implement in your company when you've had absolutely no say whatsoever because you're not a member of the representative business associations, are going to have absolutely no say over what the content of those new agreements is going to be, either in terms of what the percentage of increase is going to be or what any changes to conditions of employment are going to be, etc. So the answer is very simple. The answer is become a SAPMA member or become a Surface Coating Employer Association member, because both of those organizations will be at the table and therefore be able to negotiate the best outcome of the agreements as they impact on both parties and non-parties.
And what advice would you give a small or independent manufacturer in the surface coating sector who are unsure about how the extended agreement affects the operations and payroll planning.
So this is the big pain point. And the pain point is this. In 2 years or 3 years' time, there is going to be an extension of the Industrial Council Chemical Agreement to cover non-parties, which means that at best, you have 3 years to plan to phase in or get close, and close means within 25% of the current minimum wages and conditions of employment. So you've got about 3 years to phase in what will eventually become an absolutely compulsory situation that you have to comply with. Now, yes, you'll be able to apply for exemptions when that happens. And if on financial grounds you can prove it, then you may be granted a full or a partial exemption. But good strategy means that we sit down around your table now and we plan over the next 3 years how you're going to pay your normal increases, but at the same time, you're going to adjust for the minimum wage coming that you know is going to be coming in 3 years' time. And what that means is if at the moment the minimum wage is 10,500 Rand, and it's going to be going up by, let's say, on average 6% over the next 3 years, then you need to know that 12,500 or 13,000 is the minimum wage in 3 years' time. What are you going to start doing now to, besides giving your staff increases, what are you going to start doing now to adjust the gap between what you're currently paying someone and the minimum wage of 10,500 Rand now? And then what are you going to do in terms of guaranteeing that you'll keep to the bargaining council increases every year, even if you're not a member of the bargaining council, if you're a non-party? That is the strategic planning you need to be doing now to make sure that you're not caught with your pants down in 3 years' time.
If I am a cleaner and the minimum wage currently is 12,000 Rand that I need to be paid, but I'm a non-party, come 3 years' time, and my company is caught with their pants down, and I'm currently being paid 4,000 Rand, and the minimum wage then is 12,000 Rand, but there's another cleaner that's also in my office that gets paid 8 or 9,000 Rand because of years of experience, whatever, and we end up going to the same salary of 12,000 Rand. How does a company justify such a huge
So the
increase?
mechanism, and please don't shoot the messenger here because I represent you, the employers. But the mechanism that's suggested is that you would have to do a rate adjustment, not an increase, a rate adjustment to an acceptable level, and possibly you describe it as a band adjustment, so that you move the person from 4,500 Rand to as close to the average of, let's say the average is 7,500 Rand, and then everybody starts moving up. Everybody starts moving up to at least be at the 12,000 Rand mark in 3 years' time. But some will be beyond that because of the affliction of time and the fact that they've been in the company for a longer period of time. So the bad news is you're going to have to make the change. You'll most probably be able to qualify for an exemption application to the bargaining council when it's eventually gazetted that it now affects non-parties. You must probably be able to apply for an exemption as long as your financial statements can justify the fact that your company cannot absorb that all at once. You'll most probably get another 2 to 3 year period to phase it in.
If I apply to the bargaining council for an exemption, and let's use January as the date that we've said that the minister has extended the agreement from. So from the end of February 2026, I need to make sure that the minimum wage is paid to all employees. And my company cannot afford that. I have applied for an exemption for my company due to financial commitments and the lack thereof. How long will it take the bargaining council, firstly, to view that exemption and approve it or decline it? And what do I do in that interim period? Do I implement the minimum wage, the new minimum wage, or do I not implement anything until I've heard back from the bargaining council regarding the exemption?
So remember that the application for exemption is done on the basis of agreement with the trade union or the employees in your business, which means that if you've applied for an exemption from the bargaining council to the extended agreement, then you do not need to make any changes until such time as the exemption has been ruled on one way or another. The bargaining council is reserving the right to resolve the extension applications within a 2-month process. It may very well take longer given the number of exemption applications we anticipate. And so the answer is you don't do anything out of the ordinary until such time as the exemption has in fact been ruled on one way or the other. If a company is covered as a non-party by an extension agreement from the minister and doesn't implement that agreement, the trade unions will do the following. They will apply to the CCMA for a demarcation dispute, forcing the a non-party to recognize that it belongs to the National Bargaining Council for the chemical industry. And the moment a demarcation order has been given by the CCMA, there is a demarcation officer in the bargaining council who will automatically then apply registration protocols to that non-party and ensure that you start keeping to the tenets of the law, the industrial chemical agreement and all the other agreements which have been extended for non-parties. So that loop has been closed with the advent of the demarcation order that the trade unions would apply to the CCMA for against your company. So you just need to bear that in mind. I think it'll only become real once companies start appreciating the impact that such an extension is going to have on their bottom line. In other words, on their expenses, which are potentially going to skyrocket unless they get in front of that problem now and start on an incremental basis doing something about the challenges.
I think that's a very important point because as you say, as long as you're ahead of the train, and you potentially build on that, I think it's a step in the right direction. So I think the main call to SAPMA members is to rather be in front of the train and know what's coming so that you can prepare from a payroll point of view and operational planning, and strategically so that it doesn't have a huge knock-on effect when it does get extended. And it's not if it gets extended, it will be extended. So it's a matter of time that the Minister of Labour does extend those agreements to non-parties.